Hello and welcome to another Question Time live stream here at the Hoeg Law YouTube channel. Virtual legality. Hopefully we're going to get a couple of people in here to talk with me about some of the questions that patrons have posed, some of the questions that the community has posed. As always, since I never trust the live streaming technology, I never know which buttons to hit or whether I've hit them correctly. If you could confirm that you're hearing me, someone in chat, I would always very much appreciate it. Now, we do have a couple of patrons that have asked a series of questions today, so we're of course going to cover those first. But otherwise, it's a pretty slow month in terms of fast-moving pop culture news, video game news. I think it's the end of summer for a lot of folks. So once we get done with the patron questions, we will of course have time for community questions. But I'm expecting that this episode might be a little shorter than usual. So if you've got your questions, now is a good time to ask them. And if you don't have any questions, then just sit back, relax, and hopefully we have some fun stuff to talk about today. Now, if you aren't familiar with Question Time here at the Hoeg Law YouTube channel, this is a Patreon-supported stream broadcast that I do once a month at the end of every month on a Saturday, usually, depending on schedule, at a time that works for me. I know it doesn't work for everybody. We'll definitely be continuing to examine that time. A number of you have talked to me about that. But, of course, it's a busy world, and we got to try to fit this in where I can fit it in and hopefully have a great conversation with all of you. If you're interested in checking out the Patreon, please do check it out. One of those tiers at the Patreon is a tier that allows for question time and for the posing of questions. When you pose a question on that Patreon, it comes out looking a little bit like this, and I'll cover it in each monthly Question Time episode. So without further ado, let's talk about some of the questions that have been raised to me this month. What are the laws each adult should know and keep in mind during their everyday life? Probably federal ones, since state ones will be different for each state. And that's true. One of the things that's important to note whenever you're talking about laws or legality or anything else is that if you're living in the United States, you live under what we consider to be two jurisdictions, right? You've got a federal jurisdiction, the federal laws that apply to you because you're a citizen of the United States, and state laws, which apply to you because you're the citizen of whatever state you happen to be the citizen of. And the interesting part here is that probably the law that most folks violate the most often right now is going to be the marijuana laws, is going to be laws that are allowing marijuana usage in the various states, and it's a lot of them, including my own Michigan now, but that haven't changed at the federal level. You know, if the feds wanted to knock down a dispensary or somewhere else in one of these states, they could. It would be terrible politically, and it wouldn't happen for any number of reasons that we could talk about on a more long-form episode on this question. But it's still worth noting that even if the state of Michigan or California or Washington or wherever allows you to do something, if it's still illegal at the federal level, and the feds have the authority to make those kinds of determinations, which it hasn't really been argued, at least of late, that the federal government can do, then you're technically a federal criminal, even if you're complying with your state or your county or your municipality's laws. So when we talk about laws each adult should know, I think the most important thing is to understand that there are multiple jurisdictions. Every citizen of the United States, or probably most other jurisdictions around the world, don't have the ability to read every page or every sentence of the laws. And that's one of those questions that you get into in law school is, when everybody is a federal criminal by some metric, what does that mean to the enforcement of laws at the federal level? Or the same goes for the state, but the federal level is the one that's the most concerning because it covers everybody of these various jurisdictions and sizes and types and whatnot. So technically, if you are smoking up something and you're doing it in a way that the feds consider illegal, then you're a federal criminal. The other things that are the most common to not follow are things that you probably expect. Jaywalking, speeding, things along those lines, where essentially the human experience has said, well, they're unlikely to catch me, they're unlikely to do anything about it, and I'm unlikely to get hurt, right? Jaywalking is designed to actually protect pedestrians, but sometimes pedestrians decide they don't need that protection, and that's the kind of common laws that get violated all the time. So I think that's really the conversation piece there, is that you don't know all the laws. There are a bunch of laws that don't even apply on any daily basis. And if you are interested, the last question here is, what sources could you advise for educating oneself in the 2 points above? You definitely want to look up basically that question, probably in your jurisdiction, of what's the most commonly violated laws. You're probably going to get a list of something like that. It's going to be drug use. It might be drinking or underage drinking, speeding, jaywalking, the things that you think about. The more unusual question, I think, is always, hey, you're probably a federal criminal for 65 reasons that you don't know. So I do recommend a book done by the Twitter account Crime a Day, Mike Chase, that is called How to Become a Federal Criminal, and just talks about, laws from like 1820 about wrestling a bear in the town square and things that clearly came up once upon a time and that the legislature of the state or of the city decided were things that needed to be covered. And I always love that, right? This might be a lawyer thing, but when I walk into a play place or somewhere else and you can see the warnings on the walls of don't jump a tricycle onto the bouncy house, and you just, if you're me, imagine the ways in which this happened that led to some lawyer somewhere having a warning that went on the wall about tricycles on the bouncy house, because that's the kind of thing that lawyers enjoy. So if you do like weird rules, weird laws that talk about laws that you're probably violating or that you might violate and not even know it, you can check out a book like this, How to Become a Federal Criminal. And there are other versions of this. If you want to get political, there's versions of this kind of concept about federal crimes and government usage of law enforcement and discretionary prosecution. You can go as far as you want here. This is a humorous book about the various laws on the books, but obviously you can go into a more political philosophy bent if you are so inclined. So I think the laws that you should know about are the ones that are going to affect your daily life. It's the ones that you think about when you're driving, when you're walking, when you're imbibing, whatever else it might be. They are violated all the time. Whether or not you get punished for them is an open question. And that open question is actually a philosophy question, which is, if you're discretionary of everyone that is always violating the laws, doesn't that give a lot of authority to folks that otherwise enforce those laws? And I think the answer to that is yes. And that's how you can start to see systemic issues if that discretion is used in a way that is untoward. But thank you very much for these questions. I appreciate them. And we have one more slide here of questions, and I pulled this from a longer list because I wanted to talk about a few things that weren't directly related to the legal kind of concept, but are related to what you hear me talking about all the time when I talk about either my personal life or life away from analyzing statutes and lawsuits. So the first question is, as a lawyer, business owner, parent, you seem to use the marathon session style of video game playthrough when you have free time. You've mentioned playing video games with your kids. How do you approach balancing screen time with them? And I think these are great questions. The first, related to marathon sessions, I think that probably is what I do. I haven't really thought about it or framed it out that way. It's a matter of when you've got time and you don't have obligations, you better use it for what you want to do in terms of free time. And so, the Ghost of Tsushima director's cut just came out, and I have been using my time to play that. When I'm not playing other things, which we'll probably mention as part of this video, since I made a tweet and social media post that got some attention that a number of folks think I was unfair in one of my reviews, and I want to talk about that a little bit with you all. But yeah, I think the marathon session is probably what works for me the best, and you go and you find your time to play something like that. However, I'm also the kind of gamer that you can probably tell like some variety. So I'm generally playing a number of things at one time, and I'm always playing at least one game that is kid-friendly, so that if I'm in the middle of Ghost of Tsushima and I really don't want to share that with my youngest daughter in terms of violence or anything like that, I will be simultaneously playing something that we're either playing together or that is something that she can sit there with me and engage with together. So I'm also playing Garden Story. I'm also working through, and I always get the name of this wrong, but it's the Little Big Planet platformer. I think it's Sackboy's Big Adventure with her. She's enjoying Chicory and other things at the same time. So when we have that time to play together, if she wants to spend that time with me, we just kind of rotate off of Assassin's Creed or Ghost of Tsushima. The interesting thing that happens in my life, and it might happen in yours on that note, is that essentially if you're by yourself, I like all kinds of games, including family-friendly games, and I have my whole life, you wind up feeling like it's a quote-unquote waste to play those games if you're otherwise able to play something that's more adult is probably the wrong word, but at least more violent. And so you get into this weird pattern, at least I do, where you wind up playing those games specifically if nobody's around whether or not you want to, because you could always play Garden Story or Chicory or Stardew Valley or whatever it is when there's somebody around. In terms of balancing the time, I'm probably a little bit more lenient than some parents on this. As you can probably tell, I attribute a lot of my at least pop culture education, but probably more Greek mythology, reading, typing, to my love of video games from a very young age. I learned a lot of stuff. I learned a lot of language and vocabulary from those things, and so I'm maybe a little bit more lenient, but I do watch what they play and make sure that it's something that I think is okay for them. I think the one exception to that is my youngest really does love playing things that I would consider to be cash grabs on like the iPad, whether it's a tower of cats or things along those lines. And so what we try to do with that is we try to teach economics and loss and expenditure as part of that because they would otherwise put $20 into a specialty cat or things along those lines. So it's a matter of allowing them to do this because I think the world is such that you're going to have these interactions, and I think video games are a good entry point into using technology, but guiding it in such a way that is hopefully fruitful and not just buying $20 cats. You never know. But thank you very much for the question. Regarding the lawsuit against Activision Blizzard, you noted the potential for a conflict of interest with your brother being an Activision Blizzard developer. In this situation, is there a way for you to convey his point of view without having to wait for a settlement plea deal ruling? I'm personally interested in hearing his perspective, even if it's limited. And I thank you for the question. I've gotten a question like this from a number of different quarters, and I want to clarify my position on this because I think it's important. So my brother works at High Moon Studios. As you probably saw from Activision's press release or trailers or anything else, basically the whole kit and caboodle at Activision is making Call of Duty at this point in time. So that includes my brother. And I note it when I'm discussing the lawsuit because he's a part of that family of entities. But I don't consider it to be a conflict of interest. If I thought it was a conflict of interest, I wouldn't make the video at all. What I've done essentially is firewalled my brother, and I don't ask him his opinions on these things. I don't want his opinion on these things because I don't want them to influence the video coverage that I'm doing. And I don't think it's biased. I don't think there's any problem with that. But I know that if I were sitting on the outside of a video like that and the person that was making the video was related to someone that worked for one of the companies involved in that particular litigation, that I would want to know about it. And so I think you hear me say that when I give the disclaimers. Essentially, I think I'm doing fine. I don't think this is a conflict. I think I'm being fair, but you can judge that for yourself. That's why disclosure is important. Sunlight is the best disinfectant. So I don't think I have a conflict of interest in this because, if anything, I might be harder on Activision Blizzard. It's hard to say because my brother works there, but I'm trying to do what I do with every other litigation or any other story that I cover, whether it's Epic versus Apple or anything else in this vein, which is I try to analyze it, I try to look at what is happening there, and I try to tell you what I think is happening in those documents or otherwise. Now, some people still come into the comments, as you probably have seen, and say I'm biased one way or the other. I think that the biggest thing people don't either understand or is just a nature of the timing of the thing is that when you're reviewing a one-sided document, like you're reviewing a complaint from the state of California, what's going to come out from my side of things, the video or podcast or what have you, is most likely going to be pushback on that because they are ostensibly presenting their strongest case. And that's what they're supposed to do. I don't have any problem with California doing that way. But then I look at it and I say, well, this and this and this goes too far, and this is how this is being used, and this is how this is being reported, et cetera, et cetera. One of the things I've told people in the comments to my videos now is when Activision makes their response, it's very likely to feel that same way. They are going to present a one-sided strong response, and I'll look at it and say, well, this is the places where they go too far, and this is how they get this wrong, et cetera, et cetera. That's how Apple versus Epic basically worked the whole time. And so I think what winds up happening is people think you're biased on one side or the other. I am trying my darndest to present the different parties' positions as best I can while also saying, I don't know that one meets the level that they are asserting when they're talking to the court about this question. And I strongly expect I'll get the same from Activision because, frankly, in respect of the messaging from Activision and the way they've handled things outside of the legal process, I haven't been impressed. So it's one of those things where I strongly suspect you'll see that when and if they actually file a defensive statement. But that hasn't happened yet, so I do understand folks, reading it as biased one way or the other. In terms of actually conveying my brother's view, I don't feel it's my place to convey his view. I think there are a number of Activision Blizzard employees that are obviously out there being very public about how they feel about the situation, and I think that is totally within their rights, but it's going to be a decision that everybody makes individually, and I didn't want my brother to feel uncomfortable, threatened, or misdescribed just because his brother happens to have, what's becoming a pretty successful YouTube channel. So rather than kind of take that ground for myself and put him in a situation that he might not want to be in, I'm essentially allowing him to talk when and if he wants to talk. I'll tell you, he's a pretty private person, Thabto's notwithstanding, but I expect that he has feelings. I'm just trying not to dilute my own with that kind of crosstalk. So that's the reason you don't hear from him. That's the reason you won't hear from him before we're well past whenever this actual action would be finished. But I appreciate it. It's also one of the reasons why you're not seeing Thabtos that we might have otherwise been able to do. He's obviously been very, very busy this year, and he wanted to do more of them, and he apologized for that. People ask about Thabtos all the time, which is awesome. But since this started, I basically told him he doesn't want to be any part of the channel. Not because I don't trust you all with your questions and your discretion, but because it would be a bad situation, and I don't want him to be evaluated separately because he's going on social media and talking about stuff in a way that maybe the employer wouldn't like, and I don't know whether that would be the case. But that's really me protecting my brother, who I love to death, and maybe even being overprotective about that. But that's why you won't see that. I appreciate the question, though, and I'm very thankful to everybody that's interested in the topic. Now, I'm going to get to community questions in just a second, so please, if you have any, at Hoeg Law, super chat if you want, but that's not required at all. Just let me know if you've got any of those questions. First, I'm going to talk about something that a lot of people got on my case for, and I respect that. I respect people getting on my case, and that's the game 12 Minutes. Now, this is a game that is ostensibly, what do they call themselves? An interactive thriller about a man trapped in a time loop. And that is, in its broadest sense, correct. But it's about a lot more, and it's about a lot more in a way that I very much didn't care for. If you did see my tweet the other day, I said that 12 Minutes, now completed, is bar none one of the worst games I have ever played. Its execrable design is exceeded only by the story it chooses to tell and the way it chooses to tell it. I regret every minute I engaged with or looked forward to it. 0 out of 10. Now, I'm not in the business of giving reviews very often, or Twitter reviews, certainly. And a number of you have asked me to do a postmortem on this. I might still do a postmortem on this because I think there's an interesting juxtaposition between 12 Minutes, which is something of a darling in terms of how it's being described and the reviews that it's gotten, and The Forgotten City, which I discussed with you all last month and is one of my favorite games of the year. I can give you a spoiler. The Forgotten City will be on my top 10 games of 2021 list. And they both involve time loops, and they both involve player knowledge that exceeds character knowledge, or at least NPC knowledge of what's happening. And they both deal with that situation in a very different way. But while 12 Minutes is essentially locked down to reading the mind of the developer, right? You've got these relatively short time loops where you're James McAvoy, you're married to Daisy Ridley, Willem Dafoe comes into the room every 5 minutes, tries to arrest you and do various other bad things. That's in the first 5 minutes of the game. It's not spoilers. And you have to try to deal with that. That 12 Minutes works out, you're dealing with that in a way that is essentially just trying to figure out what and how the developer wanted you to deal with this situation. Whereas on the opposite side of things, The Forgotten City has figured out how to understand what the player knows when they know it, and how that might be detailed in dialogue to the other characters. So you get the feeling of actually being in Groundhog Day, or if you prefer Happy Death Day, or any other time loop story that you like, where the character itself is getting information and you're solving puzzles with cleverness and the information that you're gathering, versus 12 Minutes where the character is essentially always just kind of not understanding the situation until you stumble upon the 6 events that lead you to a dialogue choice that leads you into the next area that the developer wants you to be in. Now, that would be bad enough. That would be bad enough to get a low score from me, but it's not a 0 of a score. The 0 comes from not just the bad design, but the story it chooses to tell. And I'm not going to go into spoilers here. Maybe you love it. Maybe you've already played it. But 12 Minutes tells a story that can be described at best as airport discount penny novel or dime novel, of just being really slimy, shady, dark, in a way that it never quite writes itself out of. The story elements that 12 Minutes wants to use require a deft writing touch, a writing touch that can win an Oscar or something along those lines. And 12 Minutes just doesn't have it. So what you wind up feeling after you finish this game, at least for me, is spending a lot of time trying to guess the developer's intentions, read the developer's mind, never feeling clever, just feeling like you're trying to find the golden path that was in the developer's head when they made it, all in service of a story that isn't properly presented, isn't great in and of itself, and actually makes you feel worse when you finish the game. So that's 12 Minutes. Now, the 0 out of 10, which is really why this got attention, is an interesting kind of question, and I'll answer this, and then I will take questions from the community. I apologize for this little sojourn. But in my opinion, the scoring here, the review here, is my telling you what value I ascribe to the experience. It isn't kind of the old GamePro, well, the graphics are a 4.5 out of 5 and the sound is a 4 out of 5. It's not this elemental kind of thing. When I look at a piece of pop culture, whether it's a video game or a movie or a TV show, I'm only trying to convey whether or not I think it has value for you to experience, how I felt experiencing it, and maybe give you some information about what that is to me. In respect of 12 Minutes, I feel that it has no value. I feel that it wastes your time. I feel that it's bad design. I feel that it's a bad story. And I feel like the acting is bad, with the exception of Willem Dafoe. I don't know what John McAvoy or James McAvoy, who I love, is doing. I don't know what Daisy Ridley is doing, but they're doing something. They just sound like average or poor voice actors throughout the game. And so I don't think there is anything to recommend about it, about the experience. So I give it a 0 out of 10. Reasonable minds can differ on that kind of thing. I got a lot of people saying, oh, it should be at least a 4 or that kind of thing. If that's a 4 to you, label it a 4. That is totally fine with me. Numbers are silly. But to me, this was something that I really, really hated. And I wanted to convey that to folks who are bothering to read my Twitter. So that's how that comes about. Play the Forgotten City. And let's talk about some questions from the community. Let's see. What up, Hoeg in chat? A parenting book by Rick. Reasonable minds can differ, but as a child know that you are inherently unreasonable. Well, you know, they flirt with reasonability, right? Children are awesome, but sometimes they're very reasonable and often they're not. Hi, Hoeg. Thank you for your videos on the Activision Blizzard case. I love listening to your coverage on it. Oh, thank you. Yeah, I wish when we had really big series and really interesting conversations with a lot of people that they weren't always so existential or otherwise feel bad. I'm going to try to find some more series that are positive. I like doing the Game Developers Agreement series. But yeah, I think it's an important conversation. I think people are interested properly in what's happening at one of the biggest game publishers in the world. And I think hopefully I can add a little bit to the reporting there in terms of my background and experience in a way that is sometimes lost in the way I'm seeing the stories covered. And that's one of the reasons I did the video, even while I was on my way out the door this week to talk about the amended complaint that California filed against Activision. I appreciate you being upfront about all that. Let's the listener or viewer decide, about my relationship with my brother. Yes, I do. And I'm not always great about actually including that in the video because the series is so long. So I do try, but it's one of those things where I really don't think it's a bias point for me. So I have to remember to do that. I don't think it made it into this week's video on Wednesday, for instance, but I certainly try, and I appreciate that you appreciate it. Can Twitter have a legal problem for allowing the Taliban on their platform? They are seen as a terrorist organization by the U.S. government. Yeah, I mean, Twitter can have legal problems on any given day because anybody can have legal problems. You can see that the U.S. legislature is constantly evaluating what, if anything, they want to do about all these social media companies. So I think the Republicans and Democrats are ultimately going to get together and regulate something. In respect to the Taliban themselves, the question is the same as when you look at the Twitch terms of service or anything else, which is, are you limited as a platform from taking action only based on the things that happen on your platform? And the corollary to that, which is the question that you raise, is that a defensive shield if you say I'm only going to cover stuff that is on my platform? I think Twitter is probably pretty safe in making these decisions right now in the current legal environment if there isn't anything on their platform that violates their terms of service directly. And I got to be honest with you, I'm not following the Taliban or their spokespeople, so I don't know the answer to that question. But could they have a problem? Yes, they have the same public relations problem that all social media does right now, which is that they keep poking the government bear, and the government bear is going to bite back very soon, I would say. But in terms of how they actually operate, if they can't point to something that violates their terms, they don't want to do anything about it, I think they're probably okay. Now, we also talked about some of the other stuff that they banned last year, especially as being a little bit dicey for actually violating their terms of service. But end of the day, they're still, right now, ostensibly a private platform. And if that doesn't change, they can make decisions on their own, even if they're dumb. Let's see. 0 out of 10 almost sounds non-functional to me. In my opinion, 1 out of 10 conveys it as game, just really bad. Yeah, and that was one of the arguments that people made, is it says it sounds broken. And I said 0 out of 10 doesn't mean to me that it bricks your counsel or it steals your credit card information. 0 is just reflective of the value that I ascribe to the experience. No, it's not broken. It's not the kind of game that is just ones and zeros or that sound screeches at you. And I think the other component of this is that there's a level of video games that are obviously broken, that are asset flips, whatever they might be. And chances are I'm not giving my impressions on anything of that level. So the 0 out of 10 is essentially a 0 out of 10, the worst of the worst for the games that cross some kind of threshold of actually putting resources in, putting design in, trying to entertain me in some fashion. And what I find 12 minutes to be is an utter failure. But you should note, even in that thread that you can check out, that a number of people like it and a number of people defend it. I will never tell people that they're wrong in their own experience. And I think I put that in the thread as well. That is up to you. And I put my thoughts out there, and I put them out there so that people know what I'm thinking and what you might feel from the game in question here, 12 minutes, but other things that I've talked about in the past. That doesn't make me right. I'm just one person, just like anybody else. But I think it's a useful information point. I had a lawyer that was suspended from practice at the beginning of my case before he did any work on it. That's always a good sign. You know, the interesting thing about the bar is that very often it's actually pretty hard to get suspended or disbarred by one of these organizations. They are, in general, a trade group that's designed to protect lawyers. Yes, they enforce the ethics rules around them, but one of the things that is, in my opinion, maybe not so great is that they don't do a lot unless you do some very specific things. Generally speaking, you're going to get suspended if you steal money from the clients, and sometimes sexual relationships. But very often, it's going to be a slap on the wrist. So if they got suspended at the beginning of your case, that's never a good sign. I'm very sorry to hear it. I haven't received my money back. I'm not sure if I'm able to get it back or how to go about doing so. I've been unable to make contact with the lawyer because they have been unreachable. Any tips? Yeah, I don't know. The Bar Association, that kind of thing. It sounds like a bad situation. And certainly if money was paid or if a retainer was paid, that can be a tricky thing to go get back, which is one of the things we talk about when we talk about contracts and things along those lines, is even if you have the rights on paper to go get something back, if somebody's in breach of something, whether it's the terms of service of a company we cover or otherwise, once the exchange of property or value or money has taken place, it's very tricky to get returned. So I wish you the best of luck on that. Question, does the Cameron developer class versus Apple proposed settlement have any potential impact on other cases yet decided, or potentially for other people considering launching complaints? You're asking me if it does anything to Apple versus Epic. You don't have to hide the ball on this. Yeah, so if I had been in town yesterday, I would have done a video, and I might still do a video early next week about the Cameron settlement with Apple. And this is basically a group of developers that were upset about pricing mechanisms and the way Apple treats its developers. Not identical, but similar in nature in terms of complaints to Epic versus Apple. And they announced a settlement the other day that was primarily going to be designed around Apple continuing to support its small business support, I think $100 million, continuing to have a lower cut for people that aren't making $1 million on the App Store just yet, and what they consider or describe as major concessions in no longer preventing folks that have an app in the App Store from emailing their customers and offering discounts or telling them that they can buy IAP, in-app purchases, elsewhere outside of the App Store environment. Now, the interesting thing about that, and again, this is a spoiler for a video I might still make next week, is that if you remember in Apple versus Epic, Epic wound up fighting with Apple on this point, and Apple said, no, we never cover emails that are outside of our ecosystem. That would be silly. That would be anti-competitive, Your Honor. We just say that if it's directly tied to the registration process, you can't use the apps to collect emails solely for the purpose of moving people off the platform. And Apple seemed to have the argument that it was essentially a close in time kind of concept, where if you just bring them in and then you email them immediately, that's a problem. If it's later on because you have their email due to their use of your app, that was fine. And that was Apple's position in court, and Epic read through the provisions and said, I don't see that anywhere. And Epic was right, basically, on this point. And Tim Sweeney was right when he tweeted about it yesterday. And what Apple has done as part of this settlement is change the language in their app developer guidelines to basically say, just for the record, you can always email people whatever you want. Is that a major concession? I don't think that it is. It is the kind of change that we've talked about here in Virtual Legality as being expected coming out of Apple versus Epic. I've long said that Apple has the better argument in the case. I expect Apple to win 95% of the case, and I expect the court to probably have a provision there that gives Epic a small win on modifying or prohibiting certain versions of Apple's anti-steering rules, the rules that Apple would impose on developers to prevent them from telling folks that they can buy the in-app purchases or what have you outside of the App Store environment. So I still expect that to be roughly the same. I don't know whether the Cameron settlement informs that decision. It doesn't really, insofar as it doesn't change any of the analysis that would have been done on Epic versus Apple, presumably already. I mean, we're getting at the end of August. I would have expected the decision in August. It doesn't look like that will necessarily happen. So we're on 4 months or so already of consideration here. Does it change anything? I don't think so. But it does actually mirror what I expect Apple versus Epic to wind up as, which is very limited changes to the Apple ecosystem. Thank you for the question. Why did the Taliban annex Afghanistan? You'd have to ask them. Geopolitics is not my wheelhouse. Question: what will happen if California wins the case against Blizzard? Fine. Judge will require changes in board or something else. So there'll definitely be a fine. If you go and you look at the case, they ask for damages, so it's technically not a fine. It's recoupment of damages for the individuals that would have been harmed by the environment that Activision was in. They also ask for court injunctions and other equitable measures that the court deems to be appropriate. So what would happen is if it goes to court, then if it looks like California is going to win, or if it even is held to win, then California will essentially say what they would like to have happen, and the court will adjudge that. Will it require changes on the board? Courts in general are going to be reluctant to specify specific changes in the corporate governance. It's going to be a question as to what California does. California, as we've noted in the series itself, is a bit more aggressive than other states on this score, so they might have some specifics. We also talked as part of the series about the fact that California currently has a law in the books that is being challenged, and I suspect will lose its challenge at the end of the day, that requires a certain number of women on the boards of directors of these companies, and so there might be some kind of movement towards that. But ultimately, California's primary methodology here is going and trying to get a lot of money, trying to make Activision look bad, not because of animus, but because that helps make changes that California wants to see in these companies. And more specific, injunctive relief would be an open question. It's an equitable kind of concept that a court can do what it wants with. Thank you for the question. Thanks for the answer, Rick. If when you do the video on the settlement, I look forward to watching it. Yeah, and it would have been yesterday, so I might still do it. It's interesting, but the big thrust of that video and my comments on it is Apple really didn't give up much of anything. So I think that's all the questions that we have. As I said, it's only 10:30, so if you have any more, squeeze them in. I'm happy to be here, but I also don't want to waste your time on this beautiful Saturday morning at the end of summer. I don't know about you, but my kids are going to school very, very soon, and so we're having a few celebrations and fun times. And I think I owe one of them a garden story session after I get off here. So I think with that being said, now's a pretty good time to shut down a quick August question time. Remember, if you do want to get your questions in, you want to make sure they get in, please consider supporting the channel on Patreon. We can't do this without all your support. We have a lot of new patrons coming in next month. I'm actually super thrilled about all that, and I'm pretty amazed by the growth there. So please do check that out. And of course, September will be another month of virtual legality. I think we'll have an Apple versus Epic decision, but who knows? I've got one last question here, so let's answer it. In every career, there is the perception of elites and peasants. In the law trade, what fields are considered elite? You made it, and peasants, you get a thankless job. Thanks for all you do. So law is an old guild system, right? So law is very specifically essentially experience, and it doesn't have to be good experience. You don't have to have succeeded. You don't have to have won anything. It's basically time served. So the you've made it is equity partner. So when you hear me mention that I was equity partner at one of Michigan's biggest law firms before I left to start my own place, that's what I mean, is that I had an equity ownership. I had shares, in this case, membership interests in the partnership. So lawyers, they go in, they're first-year associates, they do what is the worst type of jobs. If you're in transactions like me, you do due diligence, which is you get boxes and boxes of materials from a target or an acquirer or something else, and you have to read through all of these contracts and try to figure out whether there's something important in them and summarizing them for the clients that are making decisions on how to price things and what provisions need to be in the acquisition documents. And the funny part about that is it's useful to getting used to reading documents when you're a young lawyer, but it's also the fact that you're also not equipped to really identify what's unusual about a contract before you've read however many I've read now, 10,000 of them. So due diligence is both a trial by fire, and it's also kind of a learning experience for the young associates. And generally speaking, you'd have a mid-level associate, which would be 4th or 5th or 6th year associate, going over the associate's work before it finally gets up to the partners who are going to be running the deal, the first chair, the second chair, whatever you want to call them, for one of these transactions. So in terms of making it, it's becoming partner, it's having control over the transactions. Before that, you're doing the stuff that is the mechanical needs of the transaction, reading through documents, potentially drafting what we would call ancillary documents, which are the ones that don't change a lot, but you still need to pay attention to, and they need to get drafted, obviously, because they need to be signed. And then making it is running the deal, is counseling the client as to how to negotiate these things, setting the strategy, how you're going to feint and dodge and weave to get what you want. And that, obviously, if you can't tell from my description, is the fun part, is strategizing around those things in a negotiation. But without due diligence, I wouldn't be the lawyer that I am today. And so due diligence is important both for getting the deal done and for learning your craft. Thank you for the question. Oh, and I have some super chats. That's very nice of you. $10 from Ravinica. Thank you for your response. The lawyer was suspended for 15 months back in 2019. He's still suspended today. It's crazy. Yeah, that's a really bad one. I don't know what that lawyer did, but that is bad. So thank you very much for the super chat, and I'm very sorry to hear of your situation. And a $5 or £5 or euro from Adam Zero. Sorry if you got this question already, but how legal is Soulja Boy saying on stream that he bought Atari? Can he be sued? Is it fair speech? Thank you. Well, for the most part, as you know, in the United States, freedom of speech, pretty sacrosanct. So you can say a whole lot of stuff, including lies and misleading statements, and not be in violation of that particular amendment. In terms of him saying it, I only know enough to be dangerous here. My understanding was he said he owns Atari, and then somebody had looked at the frames of the video, and it had been something like it was a property share or a licensing deal in which he was going to have membership interests or something along those lines of Atari. Presuming that he doesn't actually own Atari, and I know Atari said no, the only way that I can see that you could get sued is for securities law violations, because securities laws still kick in and prevent you from making misleading statements that are otherwise designed to get investment or otherwise to encourage people to give you money. So it's possible if there was some function of that, he could get in trouble. If it's just crazy talk, and I don't know the story that well, that's just going to be fine. The U.S. is pretty okay with crazy talk. But if it's not, if it's something else, if it had some more nefarious ends, you could potentially get in trouble. General rule, though, freedom of speech in the United States, very, very strong. You can say almost anything. As you could probably tell just from our videos on defamation and even copyright infringement, the law is still going to look to try to make it okay before it imposes penalties on you. Thank you for the question. How difficult is it to win a lawsuit brought against an employer due to perceived age discrimination? Thinking about some IBM employees who were let go suspiciously or forced out presumably due to age. Any case that you bring against an employer is going to have its own trickiness because the employer is going to be the holders of most of the information that you need, right? So if you're going to try to prove a discrimination case, the things that you're going to have to prove are that the decision was made specifically on grounds that are illegal, in this case, age. And the employer is going to have all the baseline information that you're going to need to go get as part of discovery or otherwise. So your complaint is going to be a little bit tough. Making the case is going to be a little bit tough. And you see that throughout. Now, I'm not a litigator, and I'm not a labor law litigator, certainly, and labor lawyers will have their own beliefs on that. But I will tell you that that kind of case is tricky, especially if you can't back it up with other kind of like-situated people that got treated differently or that got treated the same that you're going to bring your claim with. Let's say you create something and then sell it. If that product is copied by a third party, is it only on the buyer to take action since they own it now, or is it not that simple? The product is copied by a third party. Is it only on the buyer to take action? So I think this particular set of facts is kind of dependent on whether you're talking about a single unit or whether you're talking about an overall concept. So if you sell somebody like the intellectual property rights to make something, and then it's copied by a third party, the party that has the rights will have, hopefully in their license agreement, agreed upon who's going to start defending the intellectual property rights. If there's a patent infringement or a trademark infringement or whatever else there might be, you see this all the time when you have those licenses out. If you just are selling something that's mechanical in the world and you sell it to another party, then you didn't gain the intellectual property rights to that at all. So the copying is a right that is held by the original copyright and intellectual property holder. That can get trickier from there, but it would depend greatly on the contract in question. Excuse me. If you could modify the DMCA rules, how would you do it? Oh, well, I mean, number one with a bullet is that the standard for making an illegal claim that gets you in trouble should not be knowingly and materially as a standard. It's almost impossible for a copyright holder to get in trouble for making a DMCA claim because they're always going to be able to say that they didn't know that the DMCA claim didn't apply. Because as we've talked about, the copyright rules are completely amorphous. They're gray area questions. They're all facts and circumstances based. So any lawyer or any company with lawyers that are worth anything can have a memo in the file that says why they believe something is okay, and that doesn't get you in trouble. So I would change the standard because I think fundamentally in the current economy where you have content creators that, yes, walk across lines all the time. We do them in videos at length. We just talked about the Twitch streamer that was just directly streaming the Olympics as being a problem. That even though those exist, you're still going to have a number of instances where companies are not considering fair use, are just dumping DMCA notices. You're going to have situations like Sony taking down pictures of golf clubs because they are copyright violations and totally ridiculous uses of the DMCA, and they're not going to get in trouble for it because it's too onerous, it's too expensive, and ultimately it's too unlikely that you're going to win a case against them, even if it seems ridiculous to us because of that standard. So the one change I would definitely make is I would lean the other direction in terms of that standard. Now, the Copyright Office, as we've already analyzed here in Virtual Legality, is going and wants to protect the copyright holders more in a way that I think is untoward for the way the DMCA operates right now. But we'll see how it goes, definitely. Thank you for the question. Hi, Hoeg. Law school question for you. What are your thoughts from a risk analysis for someone going to a ranked 15 to 30 school in aiming for big law? Oh, 15 to 30. So the famous number for law schools, and I have no idea why this came to be, is the top 14, the T14, are the schools that generally feed into the biggest law firms in the country. So the question is, if it's not in that ranking, if it's in the next tier, what are the chances for big law? I am not in the hiring divisions of big law anymore. I will say there are certainly some firms that will only hire out of the T14 and will try to only hire out of the top, 4 that only want Yaleys or whatever it might be. In my experience, that isn't where you want to work anyway. I'm sorry to say. If somebody is at one of those firms, good for you. And I think there's a lot of great lawyers there. But in my experience, you've got great lawyers that come from tier 4 schools that worked hard and did amazing and were intelligent, but didn't have either the life circumstances or frankly, the assets to go to a T14. And there are some real dummies that come from the top 5 or top 14 schools. Now, I'm saying this as someone that graduated very highly in a class at what was then the 9th ranked law school, which was the University of Michigan Law School. And so I did have those advantages. But in my experience, even at hiring at the law firms that I've worked at, which is a number, you had a lot of good successes from the other tiers. So when you say big law, it's just a matter of whether or not you want to work for the top 20 law firms in the country, in New York or LA or whatnot. They might have feeders that are more specific to the T14, or whether working at an enormous law firm in Michigan, say, for instance, is something that's you'd be interested in. Generally speaking, I would go to the law school that you think is the best connection for you with whatever the attributes are that you're looking for at a reasonable tuition rate. None of them are going to be reasonable, but at something that you can stomach for the long term. That's what I would advise on that kind of score. Thanks for the insight. Thanks for the answer. I had forgotten about Sony taking down golf clubs. Happened. Hey, Hoeg, how does arbitration work? How do they assure it's not a biased ruling? So yeah, I think a couple of people in my comments and elsewhere have gotten confused between arbitration and mediation. Because arbitration is a court process. It doesn't go through the judiciary. It doesn't go through our court system. But an arbitrator is a judge. An arbitrator is deciding on which evidence to take in and is evaluating that evidence and coming to a decision just like you're seeing in Apple versus Epic, where one judge is making those decisions. It's just under arbitration rules that allow for better scheduling, allow for maybe different evidentiary standards, but each side agrees on those, agrees on the nature of the arbitrator, and then pays the arbitrator. It's shared across the two arbitration parties, but pays them on a daily basis. Arbitration is very expensive. Maybe not as expensive as using the federal court system, but still very expensive nonetheless. And when they come out with a decision, depending on what the contract that led to that arbitration says, it's probably going to be pretty final. With the only non-final aspect of it is that you can go and seek to enforce whatever is equitable through a court of law, because an arbitrator is just a person at the end of the day. They can't actually force you to do something. So in general, what the arbitration rules in your contract says is if an arbitrator comes to a decision that isn't just money changing hands, but is asking somebody to do something, then the party that has the right to get that thing done can go ask a federal court to enforce it. That's actually what the Federal Arbitration Act does. It says we will enforce valid arbitrations because the U.S. government has a vested interest in seeing arbitration happen in order to remove cases out of the court system that are otherwise clogging it up and using our resources. So that's arbitration. Mediation is different. It's essentially we'll all get into a room with somebody that's ostensibly non-biased, and he'll try to facilitate the conversations between the parties. And if that doesn't work, then you escalate to either arbitration or trial. Arbitration is its own effective court system. It is alternative dispute resolution. And so arbitrators are pretty important. And in terms of them not being biased, you're doing your best to agree to rules that are non-biased, and you're having some kind of process where the arbitrator is selected that doesn't have an interest in either of the parties. Let's see here. Truly agree with all that you said. It's been nailed into me that the cost of law school is diminishing in proportion to its worth. I just worry about ending up in insurance defense. Yeah, I mean, I think there's a place for everybody. I love talking about the law. I love thinking about the law and rules and incentives and economics. The practice of law is rapidly shifting in many important ways, some of which I'm trying to facilitate away from a guild model towards more access with more technology. And the unfortunate part of that movement for lawyers is that it's very likely to get more available to more people at lower cost, like every other industry in the world. Now, I think that's good in general, that more people should have access to this kind of thing. That's why I do YouTube videos for, you know, 1/50th, 1/100th of what I can make in terms of time actually performing legal services at my law firm, because I think that education and information is an important part of the process, and getting people to understand what's happening from a legal perspective is so important. So I make a lot of decisions that aren't motivated specifically by pecuniary interest, but I do think you have to take all those into account when you're deciding where you want to spend 3 years and who you want to give your money to. So absolutely glad I could help. Did Hoeg already address Apple allowing developers to link to outside of the Play Store? It's the App Store. Play is Google. But no, I covered it a little bit. You can go back when I archived this video in terms of that specific settlement. I might do a video on it. Morning Hoeg, lighter one for you. Are you and your brother playing Destiny 2 anymore? Any thoughts on what they showed off for the upcoming The Witch Queen expansion? So we play Destiny 2 on and off. It's one of those that's so grindy, at least to me, that you go in, you see some new stuff, and then you come back to it later. I still have it fully loaded and now updated on my Xbox. But I haven't played it in a little while. I did see those announcements. It's funny. I think they're exciting. I think it looks like a cool expansion. The one thing that I did notice is that 6 months for a season is a really long time. I wonder if it missed its window. And obviously it's pandemic, so that kind of thing happens. But they only have one season between when they announced the new expansion date and that date itself for a very, very long time. And I look at that and I said, that's interesting. But certainly I think there's a lot to be excited about there. And Destiny's a great game. It's just not one that I play all too often because I feel I've seen most of the tricks that it has to show me. Question, how is AI affecting law? Does it help with due diligence? Any negative thoughts on how AI will change law? Thanks again. Yeah, I mean, this is part of the answer to one of the questions that was asked about above, which is the practice of law is changing significantly. I think AI is something that's going to be able to massively democratize legal services in a way that I think is great. I'm somebody that believes in folks having access to understanding what their documents say and changing them and negotiating them and understanding their position from a legal standpoint more and better. That does mean, however, that the actual guild, the legal service provider, is going to have to both be conversant in that technology when it gets a little bit older. Legal tech, as much as people like to crow about it, isn't quite there yet on a lot of this stuff, but is also going to have to acknowledge that they have a different function than they might have even 10 years ago. And the real value in providing legal services is going to be in strategy, is going to be in counsel, right? We're counselors. That's one of the things you call attorneys, rather than just rote, here's how an indemnification provision should work. So when you see a video series like I did on, say, the video game publishing agreement, that's super useful. That's helpful, I think, to people. And a lot of people have said nice things about it. But ultimately, you can feed a number of those rubrics that you want to have applied to your contracts into some kind of algorithm that could help you work through that and get a contract fixed up 60, 70, 80% of the way before you actually go and pay an attorney for it. So what might have been a 5-hour job becomes a 1-hour job. And that's what the legal service industry is going to be from a transactional standpoint. I think that's great in general. I'm all for better living through technology. But hey, you know, I'm also somebody that doesn't try to put his eggs in one basket, right? I've got a law firm, I got transactional law, I'm of counsel to a different law firm, and I started a YouTube channel because I wanted to be able to both market the firm, talk to you all about legal services, and yeah, potentially, you know, make some revenue out of the process. And that's proven to be pretty interesting. But that's the kind of guy that I am, is to try to look at many different models for bringing money into the company. My wife's an entrepreneur. She has her own company. And that's just how the Hoegs roll. But I think it's something that's frightening to a lot of people. And certainly if you're in any of these rooms with equity partners at these law firms, you're hearing a lot of consternation in those rooms. So we'll see how it goes. I think it's great. A lot of people disagree with me. So thank you for the question. God bless your YouTube videos. Watch them as soon as they drop. That is very nice of you to say. Thank you so much. The rate at which you make videos is sometimes crazy, so I was wondering, how do you get time to do it? What does a day look like on days that you make videos? Wake up at X, get to work at Z, etc., etc. Well, the good news about owning your own shop is that you can control a lot of your timing. So mostly when I'm doing legal services, I'm looking right now at a notepad in front of me that has the 14 things that I need to get done with parenthetical dates where they need to get done by or where I'd like them to be done by. So for the most part, if there's something that pops and I want to do a video immediately on it, I can, research it. I can do the video. I can get it out. Farm to table, I think people have heard me say, in about 3 hours. So depending on when I can do that between closing calls. I can do that first thing in the morning. I can do that after all my legal services are done. And that's a lot of what I do to start up. You'll see me most likely hit the slots between like 11 a.m. and 2 p.m. because that means I did it first. And that's essentially pre-work, that I find something I want to talk about, I make the video, and then I go in and start doing drafting and things along those lines. That obviously changes when I've got emergencies or things that are done or need to be done on a quicker time frame. So that's basically how it works. One of the things I was solving in 2018 and 2019 specifically was how to get that pipeline fast enough that I could be responsive and still do the legal services that obviously, for the most part, pay to keep the lights on and feed my family and those kinds of things. So that was the thing that I had to figure out. The other thing in terms of advantage that I have, and I know some people don't believe me on this, but it's true, is that I don't script what I'm saying. So for the most part, you will see a video and it's organized. Obviously, it's the tabs that I'm hitting. It's the pages that I'm showing you. It's what I want to do in terms of order of my argument and discussion. But it's just coming essentially straight from me, which means that I don't have to go through a scripting process. If I don't cough or do something really stupid, I can mostly check levels and then put it straight up on the channel. So that skips out a whole extra step that a lot of people would have to do, and that I still have to do from time to time, where you have to go and edit it and upload and then export it before your upload. And if you can avoid that, that's always the goal every time I sit down to do a video. Then you can get everything up quicker and do what amounts to 2, if not 3 separate jobs on any given day. But as I've also said in my comments, I like to work. I like to be busy. I like to be intellectually engaged. And so I do this and I fill in time, whenever I have it, because that's how I like to live. Okay, so amazingly, we're at 10:55, so only a couple more minutes of questions here. And I very much appreciate everybody's participation. This has been awesome. All I had to do was say I was leaving at 10:30 and in the questions came. So I very much appreciate it. Let's see here. I liked your vid about the eviction moratorium. Thank you. To what extent is the oath of office relevant in impeachment proceedings? Is it a legally binding oath? Yes, but not legally binding in the sense that you might think. It's an oath. So the impeachment process is an inherently political one, insofar as it's essentially whatever the Congress determines it to mean. But certainly historically and both in the present, violating the one thing that the Constitution makes you say, it would be sufficient, in my estimation, for at least a certain kind of congressperson to say that that was a high crime and misdemeanor insofar as you're betraying the trust of the company. The company, yes. United States, the company. I know a number of you in my comments want to think that anyway. So the country. So it's binding insofar as anything that relates to impeachment proceedings is binding. Is it a contract? No, not really. But it is the kind of thing that everyone, the justices, the Congress, and the president says that they'll defend the Constitution. And you saw over the weekend that the Supreme Court actually moved with great deal of speediness to cut that off. Much faster than I thought they would. So you saw that kind of reaction, but it's sufficient to bring a proceeding if you want to. Obviously, there's no appetite for it in the Congress. I don't really blame people for not having that appetite. But it is something that I think is important. Certainly, the founding document requiring you to say it. It's actually one of the few things that's deliberately in there expressly, is, I think, important, and certainly could go to a discussion of whether or not the country, as either a plutonic constitutional ideal or just as a functional one, is being betrayed by saying, I don't care whether it's constitutional or not. I'm sorry, sir. Mr. Hoeg is currently unavailable. He's busy making a YouTube video. I'm in meetings or I have another function. Thank you. This was the first live stream I made it to. Very interesting to listen. Thank you for your videos. Love from Finland. I love it. That's awesome. Lol at Full House Gaming. All right, everybody. This has been Question Time Live for August 2021. I think I got the right year and month here. Again, if you like these questions or if you like supporting the channel, consider checking it out on Patreon. Otherwise, you know we do videos, and we'll do a lot more in September. Have a great weekend, and I will see you next week. Thanks so much for stopping by.